So we have some important news on the current efforts to remove suppressors and short-barreled rifles from the NFA nationwide. 15 states just joined in support of ending all the remaining NFA restrictions, and this could now be impacted by the Supreme Court's interest in SBR restrictions. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR isn't a league of their own. AOR is an actual, company that's backed by a real law firm, Attorneys for Freedom, and they can help you in self-defense situations that maybe other companies would not. So one of the really cool things also about AOR right now is they've expanded their benefits. You can get things like civil liability coverage, red flag law coverage, expungement coverage, and a lot of other things that are now included in their benefits. So I highly recommend that you sign up this year because I believe next year they're going to be increasing some of their prices. So check them out this year. You can check them out using my links down below in the details section, also in the pinned comment. And if you use my code ARMEDSCHOLAR, you can get $50 off of an individual plan or $25 off of a family plan. As I mentioned in the intro, in this video, we need to talk about what is happening right now in response to the Hearing Protection Act and the Short Act, which did not get passed in the full versions, that we wanted in HR 1, the big beautiful bill. Now, if you've been following the channel for a while, you know that HR 1 passed, and in that bill and in that law that's now been signed, we did not get the full, removal of all the NFA restrictions on suppressors and SBRs. Instead, we only got a reduction of the tax. Under the new language, the NFA tax has been reduced from $200 to $0. Unfortunately, rhinos in Congress were unwilling to press this issue to get the full version of the language that we wanted, and they were also unwilling to remove the Senate parliamentarian who was responsible for striking out the full language that we wanted. One of the things that we were also concerned about coming out of that was that with the NFA tax change, maybe Democrats would try to follow that and maybe try to use that to their benefit. Recently, we saw that Senator Chris Murphy introduced a proposed amendment to the military spending bill, which would increase the NFA tax requirement all the way from the $200 to $4,709 per stamp. So the Democrats are responding to this, change in the NFA tax, and they're taking action in response to that. But we also have multiple 2A organizations and companies that are launching challenges to remove suppressors and SBRs from the NFA outright. Recently, we saw that GOA, FRAC, Silencer Shop, Palmetto State Armory, Silencer Co., and others have filed a lawsuit against the ATF. And now 15 states have also joined on in support of that lawsuit. So the states that joined this lawsuit to end the NFA and its restrictions on SBRs and suppressors were Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming. This is great news, and even more important now, we have the fact that the Supreme Court has shown interest in 2 cases that are currently pending in front of them, which also deal with the SBR NFA issue, and those are challenges to end the NFA's restrictions on SBRs. Now, in this current lawsuit filed by Silencer Shop and the multiple organizations, they argue that enacted in 1934, the NFA is premised on Congress's taxing powers. The act imposed a $200 tax on the manufacture and transfer of particular classes of firearms. The NFA's authors left no doubt that the NFA was an exercise of the taxing power and that the Supreme Court upheld it on that basis. This has been the uncontroversial understanding of courts and commentators for nearly a century. But the NFA no longer imposes any tax on the vast majority of firearms it purports to regulate. The One Big Beautiful Bill Act, which Congress passed and the President enacted on July 4, 2025, zeroes the manufacture and transfer tax on nearly all NFA-regulated firearms. That means that the constitutional foundation on which the NFA rested has dissolved, and the NFA cannot be upheld under any other Article 1 power. With respect to the untaxed firearms, the act is now unconstitutional. They state that the One Big Beautiful Bill Act left undisturbed the NFA's registration requirements and restrictions on the manufacture and transfer, which for most NFA firearms now lacks any accompanying exercise of Congress's taxing powers under Article 1. Plaintiffs are individuals and organizations who are burdened by the NFA's regulatory requirements pertaining to these now untaxed firearms. Plaintiffs seek an order declaring that the NFA is unconstitutional with respect to the untaxed firearms it purports to regulate and enjoining enforcement of the unconstitutional provisions. So in summary, what Silencer Shop and these other organizations ask for in this challenge is for the court here to declare that the NFA's registration and transfer requirements pertaining to the now untaxed firearms like SBRs and suppressors, that exceeds Congress's enumerated powers because now there is no tax. They also ask for the court to enjoin all the ATF's employees, officers, and agents from implementing or enforcing the NFA against all these now untaxed items. So that is what this new lawsuit aims to do in response to the NFA tax change that was passed in the Big Beautiful Bill. This lawsuit was filed in the Northern District of Texas, which is a federal court, and the 2A cause has done pretty good in this jurisdiction. We've got really good, strong decisions out of the Northern District of Texas, out of a variety of judges like Judge O'Connor and Judge Kaczmarek. We got rulings in cases like the Vanderstock 80%er cases, the mock pistol brace challenges, the FRT issues. All of those came out of the Northern District of Texas. So now important for this case is also the fact that we've seen a lot of changes also happen at a variety of different levels of not just the circuit courts, but also the Supreme Court. And we have 2 SBR NFA challenges that are currently pending in the Supreme Court. Those 2 cases are the Rush and Robinson challenges that we've talked about before on the channel. And both of those ask for the Supreme Court to review the NFA's restrictions on SBRs, and they ask for the Supreme Court to find that the NFA's restrictions on those items does in fact violate the Second Amendment. In both of those cases, the Trump DOJ waived their right to respond to those petitions, but recently the Supreme Court ordered that the Trump DOJ file a response to those petitions in both of those cases. This at least means that the Supreme Court is taking some interest in the SBR NFA issue, and they are going to address that at some point during this next term. They're going to take it up for conference, and then we're going to find out whether or not the Supreme Court wants to grant review to this issue. If the Supreme Court ends up taking review of those cases, it's likely that these HPA lawsuits that were filed in the district courts will probably be put on hold, but that's going to probably be a good thing because it's a good trade-off where the Supreme Court is addressing a broader issue that will impact all of these NFA challenges. So whether or not they get put on hold, if the Supreme Court does that, that's again a good trade-off because you're getting the Supreme Court to review the NFA at large. Now, one caveat to all of this is we don't really know right now how the Trump ATF is going to respond to this specific challenge and to these issues based on how they've responded to some of these cases in the past. Maybe we could get a faster review than we expected, depending on how the Trump DOJ responds. But we've seen the Trump DOJ, and that 2A task force there take a pro-2A stance in some cases, but it's kind of been hit or miss. Sometimes we've seen good 2A, stances by the Trump DOJ, but when it appears it comes to the whole NFA and GCA issue, the current stance seems to be that they are going to defend these types of restrictions as constitutional. We saw that in recent, cases like the machine gun challenges in the Fifth Circuit, and then some other cases that have been pending in regards to suppressors. In all of those suppressor cases, the DOJ stated that suppressors are arms, that they're protected by the Second Amendment, but that the NFA's restrictions are constitutional because they operate as a shall issue permit, and therefore they align with what the Supreme Court said in Bruin. So there's a lot of moving parts now in this whole NFA battle, trying to fully deregulate suppressors and SBRs and these types of items. Lawsuits have been launched, and now Democrats are also launching their own efforts to try to increase the NFA tax. And we've seen cases, now launch at multiple levels, district courts, appeals courts, and now we also have 2 cases seeking Supreme Court review. So that's currently the landscape of this SBR and suppressor issue, trying to fully remove them from the NFA in response to the Big Beautiful Bill. It's going to be interesting to see now how all of this develops. As we get more information, as this develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys, including the free legal guide. Over there, all you have to do is put in your email and we email you over a free PDF. And then we do follow-up emails with additional educational information. And then also we have some deals and coupons and stuff like that that can save you some money. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.